So our time has come to continue our work according to our internal rules. We now switch to English language, and we will have opportunity to discuss things in 1 hour, what our participants would like to say and you would like to ask. But before we start, I will make a little remark about development of constitutional judicial review. There are, let's say, 2 stages in Europe, from 1920 up to Second World War, and then constitutional judicial review after Second World War. And this stage divides for 2 parts. One is, so to say, Western countries at that time, and later on new Eastern European countries who regain their independence. And now in our country and also our colleagues' countries, we are thinking how the system has achieved its aims and what should be done better. Of course, there are many things in different countries which are more important than others, but I proposed, and they agreed partly at least, to concentrate in our discussion for 3 main topics. First, express their views about individual constitutional complaints, how this works according to their understanding and experiences. Secondly, again, parliamentary minority access to constitutional court, pros and cons. And finally, maybe, what is the future? What needs to be done in future in this area, judicial review of constitutionality? So these are main principles topics. Of course, we can ask any other questions and deliberate as anyone wishes, but I just try to concentrate discussion on certain directions. So next to my left, sitting Ineta Ziemele, from European Court of Justice and former president of Latvian Constitutional Court. Next is Toma Birmontiene, Mykolo Romerio University professor from Lithuania. Then Jānis Neimanis and from Latvia, and Ivo Pilving from Estonia Supreme Court, and Martin Triipan, who spoke last, from advocaatbüroo LX, or LX now only. So my first question is, as I expressed, about individual complaints. How it has been justified in your system? Was it successful? What kind of problems it contains? And could you please give briefly overview experiences in your respective countries? Please, Ineta.
Yeah, right. Many thanks. And well, it's very nice to still see a rather full audience. And thanks for your interest and patience. Before I say a few sentences, which in my view are very important to characterize the Latvian system, the way the constitutional complaint, in fact, the importance of the constitutional complaint in Latvia. Let me say 2 comments that link into what was said before, just 2 sentences. I mean, first thing is, of course, our traditions will by definition be different in establishing the functioning of the judicial review of constitutionality. That's because our histories are different. And also our traditions towards the power in the society are different. Our traditions in trusting the legislator are different. And all of that, in fact, counts into then, the scope and the mechanics of judicial control of constitutionality. And there are reasons why in Latvia, at the beginning, because there was indeed a fear that just established constitutional court in 1996 would not be able to deal with the workload if it was opened immediately to individual applications. That proved not to be right, and in 2001 the constitutional complaint mechanism was opened to the individuals. Now, from then on, one thing that I would really like to emphasize is that the constitutional law in Latvia is made by people. Yes, it is majority and minority in the parliament. Of course, it's very important. We need the laws. But it's the Latvian people that own the constitution. And they own it because of their right to bring their fundamental rights, what they consider as interference in their fundamental rights by the legislator. They bring that to an independent objective tribunal. And that has, in my parallel life, I'm a professor as well, and sort of looking at these processes a little bit from an academic point of view, that really has made the Constitution of 1922 a very living instrument, because the people initiate, double-checking what the legislator has done. It is the strength of democracy, and there is no question about it. So that's one of the major achievements. People own it. And I would really want to know whether in Estonia, your society has exactly the same feeling that it owns the constitution. That's what you have to ask. So having said that example on the individual constitutional complaint, the reason why in a post-Soviet setting, and there is another reason, we really, maybe it was even a miracle why it happened that way in this period, 96, 2001. But by enabling, in a post-Soviet context, the individuals to actually realize that they have the right to privacy, realize that they have the right to fair trial, that was a groundbreaking change in the mindset. Think about it. People were not used to defending their rights. So through this mechanism in the Constitutional Court, by making the center of attention the protection of fundamental rights, we actually contributed to the real revolution in the minds of the people. It is a mechanism of empowering the individuals. And that has given a lot of good in otherwise a very complicated, and Estonian colleagues may understand very well what I'm talking, as well as Lithuanian colleagues, but it's a complicated, sort of societal developments that we have. And these have been two major achievements. We own the Constitution as citizens, and we learned what human rights are through having a focalized, mechanism to defending that, and that mechanism empowered our citizens. And naturally, the third point, individuals, by having a court in a way on their side against sort of the political parties and the fights for power, within the parliament, the people having the court as a last resort, in fact, they also bring into our society such a necessary third point of view, a plurality. You know, it's not only what the majority minority thinks within the political dealings and feelings, it is what the people, what issues the people are concerned. Just before I left for the Court of Justice, we had the whole group of cases, Jānis and myself, we were in the composition, on social rights, on social benefits, because that system was, it was not a system to begin with, that's what the court established. It was a mess in terms of retirement benefits, in terms of benefits for people with special needs, etc., etc. We had 4 judgments in the row, sort of overhauling that situation, putting it upside down, disclosing to the world that things have not been done properly to protect social rights of the individuals. Now, that's what we are talking about. And the people, through that, gain trust in their state, because the trust is a difficulty as well. I stop here.
Thank you.
Yes.
Please.
So Lithuanian experience regarding constitutional complaint is a little bit different. Though the court was established in 1993 because the constitution is of the same age as Estonia, and the constitutional court was just placed in the constitution. Before, historically in Lithuania, we had some traditions of constitutional complaint. It was between the World War I and World War II. But this constitutional court, of course, was established looking to the European experience. And the established constitutional court from the very beginning, we had really vast possibilities to address the constitutional court, but no constitutional complaint. And constitutional complaint appeared in Lithuania, was established under the changes of the constitution, because it was inevitable, only in 2019. So the question is why and how society lived, how the court was working, and why such a long period of time. Now, first of all, if we look to the individual access to the constitutional court, we have 2 ways, direct and indirect constitutional complaint. And that indirect constitutional complaint played a very great role in Lithuania. Because from the very beginning, from the very 1993, all courts, from the lowest till the Supreme Court, had the right to address the Constitutional Court regarding constitutionality of legal acts. So that's why that way was very open for the people. If they started any case, so if the address the court, and the court says that probably there is a problem with the constitutionality, with fundamental rights, stop the case, go to the Constitutional Court, gives the answer, and then things are going on. So this way was really very wide, possibilities, and people used it. At the same time, even through this channel, of course, there are another channel, there are political channels, and the president and government and parliament in corpore and members of parliament, 29 1/5, also can address the Constitutional Court. So there were a lot of ways. The Constitution was delivering, the Constitutional Court was giving a very huge decisions. First of all, through the work of the Constitutional Court, it was absolutely clear that Constitution is not a declaration, a working document. And another thing, that Constitution, though adopted in 1992, the same as Estonian, it lives together with the society. And things that probably maybe through the interpretation of the constitutional notions, the Constitutional Court, now we say that in Lithuania we have jurisprudential constitution. So constitution is what the court said. So you can't now read the Constitution and expect that this is a small book. No, rather small, maybe not small, but a book, and that's all. So the Constitution is really a lot what Constitutional Court said. And of course, and interpretation and reinterpretation, but that's another question. So coming back to the constitutional control. So one reason why so late, and Lithuania didn't get even any criticism. No, we are not Italy, but something like that in this case. So we were not, the Lithuanian Constitutional Court was not criticized, no, by Venice Commission, by any other institutions. And 2019, and why so late? No, first of all, Constitutional Court from the very beginning was a very powerful instrument and showed the politicians that it is independent, and it delivered a very strong decision, one of them impeachment, even though the president. So there was a very established, very, very solid reputation, and society supported and trusted in the Constitutional Court, not in the whole court system. So, but still there were discussions that still we are no neighbors, Latvians have, other colleagues have, and we were facing rather alone. And of course the individual complaint gives more possibilities for the individual, but still we have to bear in mind it's not so easy, because with our system we were looking to our Latvian colleagues. You still have to go all the way through the court system to have the last decision, then you coming back, and then you just discussing the legal regulation that was the basis for that decision. So this system, we have some really very good examples and very successful individual complaints, but of course, as in many other courts, we have a lot of rejected, not grounded, not best, not well written, so on and so forth. So now, bearing in mind Lithuanian experience and rather late development, I look to the Estonian, as far as I can guess, of course. I could be misled maybe a little bit by my understanding. So looking to the constitutional complaint in Lithuania, individual constitutional complaint, it could be complicated. And first of all, because the Supreme Court is working as a constitutional court also. So how can you, having a decision of the Supreme Court to raise individual complaint that your colleagues will be dealing with? It is a very complicated issue. So I think that as Estonia adopting the constitution and very different system of constitutional control, found their own way. So maybe even in the way of introducing individual complaint, there has to be some kind of some special maybe arrangements, how to make that system work, that the same judges do not work with the same issues. Coming back to the discussion that colleague you raised a little bit, that Supreme Court judges are really very good in the Constitutional Court. I was also a judge before, so I was working also with the colleagues coming from the Supreme Court. But still, even they coming to the Constitutional Court, they had to change their attitudes. Mm-hmm. They had to be, and when they are leaving and coming back to the Supreme Court or to any other court, they also feel a little bit different. What is also a value, that we have a complex of different people then. Somebody comes just from Academia. Even sometimes somebody comes maybe with some political implications, though it's very rare, but it could happen. And the judges. So for the deliberation of cases, it's a very big value to have different people, to have different experiences, but regarding, and especially for the individual complaints, because individual complaints, when you are dealing with, you are looking to the court case, to the decision of the courts, to the last decision of the court, and you have to be experienced in all this. So thank you.
Maybe ask, how big is your workload?
No, quite big if all constitutional complaints will be looked through. Yeah. Because, of course, there is a lot of constitutional complaints, but a very strong criteria. But we borrowed it from our colleagues, yes, so the situation is almost the same. Mm-hmm. But some individual complaints are really excellent, and one of them, maybe I'll give an example if I can. So sometimes we have fines, but sometimes the institution that put fines on us is not correct, but not that we are incorrect in doing something. And that was one individual complaint. The person said, sorry, I got a fine. I came to the court. Court said that I'm innocent, so that's not my fault. But why I have to pay for my advocates? Why I have to have so many financial problems? Maybe for me it was cheaper to pay the fine, but not to go to the court. No, and the Constitutional Court then said, sorry, if the state finds you, but you are so innocent in that case, so the state has to give the to compensate your losses. So I think that there are really very good things that are coming out of individual complaints.
This is a good example you gave. Ivo, please.
Yeah, thank you. I would like to comment some issues raised now here. Yes, I do think our constitution is indeed also living document and living instrument, and not just a book somewhere forgotten. The numbers we already mentioned in special constitutional review procedure, there were 600 cases during 30 years. It means 20 cases per year. Of course, all of them were not maybe so serious and fundamental. But I also mentioned that important constitutional issues have been discussed in criminal, civil and administrative law chambers of the Supreme Court, which is functioning also as constitutional court, and they are also constitutional cases, although they haven't been decided in special procedures. But the citizens who had complaints concerning their fundamental rights, they have got the answers of the courts and detailed answers, not just somehow mentioned. I do think that Estonian citizens are aware of their rights. They are protecting them, although they cannot come directly to the Supreme Court as constitutional court. They can come. But after exhausting the remedies in first instance courts and circuit courts, and by the means of normal appeal procedure, the citizens can raise all constitutional problems and their arguments concerning their fundamental rights, and they use their arguments, and Supreme Court is also answering them. Although we have the leave system, the majority of cases are decided without reasons, in reasoned judgments, but I don't think that we should somehow we should compensate the problems of leave system with additional complaints concerning the Supreme Court judgments. You raised very important question. Could the same judges who are deciding in cassation or appeal procedure the cases, is it possible that the same judges are reviewing their own judgment? No, of course it's not possible, and that's why the Supreme Court has denied to review in extra complaint system its own judgment. The question might be, do we need additional court level to control the mistakes and to review and to remove possible mistakes made by Supreme Court chambers. Of course, there might be mistakes.
Yes.
But don't misunderstand. But there might be mistakes also in the judgments of constitutional courts. That chain would be endless if we think so that all the mistakes in court procedures must have been removed and recovered. We have to invest our scarce resources to avoid mistakes in Supreme Court procedures, and of course to correct the mistakes made by lower instances. So that's why I do think that we have individual constitutional complaint, and it's well used by the citizens, but the name of the constitutional complaint is the cassation application or appeal to the Supreme Court in a normal way, as we are combined court, not pure constitutional court, but combined court. So also our applications we get are combined. They are fulfilling very well the functions of normal appeal and constitutional complaint.
Thank you. Jānis, you already have spoken
about it, yes, but
maybe you have something to add or change.
Actually, Ineta and Toma said those very precisely why we have a constitutional complaint, what are the benefits. My colleague Ivo said before in the presentation that each judge should apply constitutional law, understand it, and this is correct. But I can just show in examples how it works. In Latvia, I was in a court composition who decided that a dispute between member of local government and local government is a completely internal political dispute, and it does not belong to the competence of administrative court to solve it. Then I changed to the constitutional court, and I got this problem second time, and I said, no, it's not a completely internal conflict. It should be resolved. It's a conflict about the application of law. He or she should protect the public competence, and so this is how I, as a judge there and now, so I changed this view perspective. And we got a new colleague from the administrative law department, and we discussed this case, and she started to complain with me that we broke the administrative procedure law. Why we bring those disputes in administrative court in administrative courts? These are completely political disputes. Yes, so the disputes between a private person and the state in a fundamental rights, and the disputes between constitutional organs or the parts are political questions. For example, I participated in a case where we decided that the partner of the same-sex couple has a right to the father's leave. They were two women, and they applied for one of them applied for the father's leave. So This was, that was a civil case, labor law. But in the same time, yes, that was a huge political issue. And I was very proud, and I started to cry, really, when this judgment was read. Was pronounced through the Zoom meeting that was never shown. But so my emotions was so that I was like a Ginsburg from the Supreme Court of the United States, that I participated in this political issue, that we started to move this question through the political agenda. So you cannot everything put on the legal mechanisms and institutions, and so sometimes there should be something more. I cannot so to classify what it is, but this is like a drive.
Okay, thank you. It was quite an interesting example. And Martin, do you have something to add?
Yeah, I may add first of all, I think one issue that has been afraid in relation to this individual complaints is potential workload. And that's true. That's from this practicing lawyer's point of view, I may say that a good lawyer can elaborate and present almost each case as a constitutional case. That's for sure. That we have to keep in mind. But well, this is issue that what it is really how it's actually have impact on the workload. But very many cases can be somehow presented as a constitutional cases, But in Estonian context, as we have this Supreme Court as also the court which also practices this constitutional review. Then probably this is in our context. The question is where we have the filter, because it's for sure that somewhere should be the filter to filter the cases. I understood in Latvia that filter is in the relevant panel of the Constitutional Court. Now we have the question whether the filter should be at the doors of Supreme Court or in the Court of First Instance. This is like there's a difference in our discussion actually, and there are different views. But I understand that because in any case the Supreme Court will decide on the case anyway finally, when the case reaches to the Supreme Court. Then it's only the question where we set up the filtering system. What I think what also in my presentation I want to underline was the idea that we should not set up the system in a way that all constitutional issues should be somehow directed as individual complaints, because I think the main idea should be that the constitutional issues together with other issues should be directed through an ordinary procedure, and that we should keep this focus and the responsibility of all judges and also to emphasize that all judges are responsible for also to check the constitutionality of the relevant norms, and that's why these legal obstacles and remedies should be elaborated. But I think that individual case complaint should be there for as a last resort, also in Estonian context, as we have to some extent already. This is because there may be cases where there are different procedures, and some cases may fall between different procedures. I think. Well, we can say as regards what we have already is from the jurisprudence of Supreme Court. What comes to the individual complaints, we can say at one hand that only one has been somehow accepted, but there have been some cases. One recent case from the Chamber of Criminal Cases where although the case wasn't accepted for review, but the case was transferred to the other chamber of criminal cases, and actually the final outcome of the case was the, let's say, for change of the actual jurisprudence of the criminal cases. That was outcome of the very limited option that we have already in Estonia, but it had some impact on the final income for the relevant persons as well. And as a last resort, I think we should have it just to in some limited frames.
Thank you, Martin. Now we have a time for questions, and I see 2 hands. Now 3. Yeah, okay. You are the first. Yeah, please.
Thank you. My name is Toma Birmontiene. I'm a professor of public law from the University of Helsinki. And what I'm about to say, I think it sort of backs up what Ivo has been promoting here. And this comes from the Finnish system. And perhaps a few words about the history of the Finnish system. So we don't have a constitutional court at all in Finland. The constitutional review takes place in the parliament, in the Constitutional Law Committee, which is comprised of politicians. Yes, that's true, but consulted by legal scholars, professors, etc. And there are historical reasons for this. Late 19th century, under Russian rule, the Supreme Court of that time, Supreme Administrative Court, was manned by Russian nobility, Russian authorities. So what the Finns wanted to do to secure the constitutional review in a way that it takes place in the parliament. So it goes all the way back to the late 19th century. And what we were then protecting was the Swedish constitutions that we still had after the break with Swedes. So it's contextual. And I fully understand that countries, that have been under authoritarian regimes have mistrust in the parliament, mistrust towards politics. So a constitutional court is an obvious answer to that. But that's sort of a little bit of contextualizing. The question of individual complaints. In Finland, what we have, you could say, we have mainstreamed the constitutional review. It takes place according to section 106 of the Finnish constitution. Every court can review the constitutionality of a legal act within that specific case. And we have mainstreamed it even so that administrative authorities can do constitutional review, not of legal acts, but ministerial decrees. Administrative authority may decide that this decree by the government or by a ministry is unconstitutional. Section 107 of the Finnish constitution. It rarely takes place. I guess it never takes place. Administrative authorities do not have the competence or the courage to declare individual decrees unconstitutional. But still, there is a possibility for that, according to the Finnish constitution. But what actually the courts do in Finland, they do not declare acts of the parliament unconstitutional, but they resort to constitutional friendly interpretation and basic rights friendly interpretation. So I'm not convinced that that Estonia should open up the constitutional court to individual complaints. And as you were Ivo saying, that what the courts already do, they refer to basic rights, and they make sure that the decisions are constitutional through interpretation. And I would imagine that the cases that the individuals would take to the constitutional court would be exactly about basic rights, and this is something that can be taken into consideration in courts, so regular courts. So this sorry, a bit long speech, but I wanted to jump in and give some support to Ivo, because I sympathize your view.
Didn't want
Thank
to
you.
hurt you.
Madis, your turn.
Yeah.
Thank you very much. Yes, I thank you particularly for this contribution. But of course, as you said, it's contextual. And as a matter of fact, the great dispute of Weimar constitutional theory, the große Richtungsstreit der Weimarer Staatsrechtslehre, it was won after the Second World War by Kelsen, and with the establishment of the German and Italian constitutional courts, which are the paradigm courts actually for the modern contemporary constitutional review. But I had actually a question and remark to you, Toma, and to you, Ivo. Toma, you said that the judgment complaint inside one court could be problematic.
Yeah.
Perhaps. I, as a matter of fact, that was what I thought for a long time. But then I discovered that but we have an example, and this is the European Court of Human Rights, where there is a complaint inside one court, and which is solved in a little bit different, but in every case in a bigger panel. What do you think about that? And to Ivo, I think you said, please correct me, that if the review, the chamber, the civil chamber, the criminal chamber, the administrative chamber, debate about constitutional rights, that this is constitutional review. If this is true, I would doubt that, because in my terms, constitutional review is a process, at least, this is one of the conditions, but the outcome could be unconstitutionality and invalidity of a law, of a statute. But this is not the case for the cases that are disputed in front of civil chamber, criminal chamber, and administrative chamber. However, there are also these so-called mixed cases in front of the Supreme Court en banc, or the plenary session as a whole. These cases can derive from a chamber, and then they are as well as a civil case, for instance, and at the same time a constitutional case. In this case, I would agree, this could be considered as constitutional review, but not the disputes in the chambers, in my opinion. Thank you.
Can I answer?
Please.
Well, I would not look to the international courts like national courts. International court judges are coming from different countries for a period of 9 years. They are changing, so composition of the court and how international court operates, it is different from the national courts. In the national court, and I do not have the very good understanding, but it's a small court with the colleagues that are working for decades together. And it's a psychological problem. I trust the judges. I do not feel that there is something incorrect. But I do understand that we judges are human beings. And if we are working with the colleagues for 10, for 20 years, and we have somehow to discredit, to change their decision or just to review their decision. I think it is very, first of all, it is not very good for the court itself, because it gives some kind of atmosphere, not very friendly atmosphere. So in case if there could be some kind of individual complaint regarding decision of the Supreme Court, let's imagine. I think that Estonia is a very innovative country. You decided this way of constitutional control. Maybe you will find a way how to go out of this difficult situation.
Thank you. Üks küsimus oli veel seal. Oh, there was one more question. Please submit it.
Yes, hello. My question is directed to Ivo Pilving, but the rest of the panel is welcome to chime in if they have anything to add. So in your talk, you kind of presented the view that the Supreme Court judges should try to remain and also kind of look politically neutral, that they shouldn't kind of take sides in political issues and so on. But I was just wondering if you think there is a way to distinguish between political values and values that are enshrined in the Constitution. So if a Supreme Court judge is deciding a case, and if they're writing the decision and they want to appeal to a certain kind of value, they might appeal to a value, like a political value that comes from their political ideology, which is something that you said that they shouldn't do. But at the same time, if they do appeal to a value that's enshrined in the Constitution, then the question is, how would one distinguish between constitutional values and then kind of like values derived from one's political ideology? Thank you.
Thank you. I guess this was basically directed to Ivo, please.
Good question. Thank you very much. And as much I can answer the legal, I wouldn't talk so much about legal values. Of course, they are important, but so my idea was more to talk about legal methodology. We should apply that, and if we face question which is not possible to solve by legal methodology, we should not solve that as a judge. We should leave it to Parliament. That means we should defer to Parliament and not second guess or the Parliament's political decision. Of course, there are political decisions which are legally relevant, political decisions that are unconstitutional. But using legal methodology, the interpretation of constitution, also comparing our constitution with other countries, borrowing arguments from supranational court institutions, there is no problem to correct those political decisions which are unconstitutional. But there is no secret that we can always discuss whether some judgment is political or whether it is made according to legal knowledge and legal methodology.
Thank you.
But I will quickly answer to Madis and also a bit to comment to Madis's second question about the Court of Human Rights. I think the procedure in civil law chamber or administrative law chamber those procedures are fulfilling your condition. It is possible to invalidate the unconstitutional law, not by the civil chamber itself. Exactly, it must then start the procedure in plenary of the Supreme Court. But this is the first step. If the so-called normal chamber of Supreme Court sees no violation of Constitution, its decision, I see no problem why this decision cannot be final, why we should need some extra appeal procedure against civil or administrative law chamber. Of course, it's possible in Strasbourg, but this is the only way and only appeal level in Strasbourg. We in Estonia do have 3 levels, and the appeal system must not be unendless.
Thank you for explanation. Ineta wanted to add something.
Yeah, because the question you asked is really excellent. I mean, I think we have to accept that constitution and politics is intimately linked. It is the constitution is the basis and the frame for all of the politics that takes place in the country. And that is very normal. That's, thanks God, we have political processes taking place within the frame of law, which is the Constitution. Now, the other thing we have to really accept is that also when you speak about human rights, human rights will be ideologized. It's the meta of human rights is such that, they are kind of almost invite politicians to take positions on, the scope and content of human rights. So one has to accept that that's the way it is, and there is nothing wrong with that. What is important, and there I agree with Ivo, typically, and it's just I can confirm also from my experience as a judge in 3 courts by now, that what you would look at, whether or not from all that context, individual has a subjective right. A subjective right that can be invoked in a court, whatever that court is. And then when there is a subjective right, of course, the interpretation will be of a Bill of Rights in your constitution or of the European Convention of Human Rights will be according to the traditions within the legal system. So it is through this that even if a matter Jānis mentioned, indeed, a landmark judgment of the Latvian Constitutional Court, saying that the principle of equal rights, in essence, applies to everyone. And you have a lot of politics about it, but there was, on a very narrow ground, a subjective right that could be invoked, that was invoked, and the court adjudicated within the Constitution, of course, sort of going through its methodology. But the background of that is a general principle of equal rights. Now, I must say, my difficulty with keeping the constitution, which is the life of the nation, sort of only limited to civil law disputes, administrative law disputes, and criminal law disputes. My fear is, especially in our societies, and that definitely is not the Finnish challenge, I accept that as well, that we missed out on having the law that deals with these great principles of constitutionalism, such as equal rights, such as the principle of a nation state. I mean, that is all. If we speak about cases on language, for example. So we are missing out on that. Yes, we are very positivistic. We stay within the bounds of civil, administrative, criminal. But broadly speaking, constitutional law is obviously more than that. Well, if you are fine with that, that's of course your choice. As I said, I think the people, for example, of Latvia and certainly in Lithuania, certainly gained from having been involved actively in debating these grand principles, underlying the constitution in accordance with the methodology, no question about it.
Thank you, Ineta, for this explanation. I'm sorry, I see one hand more there, but our time is running out. We have some 5 minutes more. I want you to express your view about parliamentary minority access to constitutional court or judicial review in constitutional court, because this is pretty hot topic in our present situation, and we don't have presently in expressis verbis terms this right. What is your opinion about? Should it be or not, or is it good thing or bad thing?
It should be. It's a good thing. It's about rule of law. It's about rule of law and division of powers. And it is about the plurality. In Latvia, it exists in two ways. Jānis also before mentioned a little bit. We have minimum 20 MPs who can challenge the constitutionality of a law adopted by the majority. We also have an individual member of parliament or municipality through the individual constitutional complaints mechanism defending actually the rights that stem from a mandate, and that needs to be corrected. But you must have a mechanism in a democracy where disputes between constitutional bodies of all sorts, but in the parliament, majority and a minority, is determined by an independent tribunal. That is very healthy for the democracy.
Thank you.
Yes, in Lithuania, yes, and as I've told before, there's from the very beginning, courts and politicians were the clients of the Constitutional Court. And we have very good cases, but this is just a lecture, so it will be a very long story. I think, yes, it is very good, but at the same time, the opposition, though we do understand that this is a right of the opposition, sometimes even this civil society asks why opposition do not address the Constitutional Court, because they understand it like not even a right of the opposition, but like a mandate. So the opposition, through this, they can much more easily protect the rights. So that's why sometimes we have some kind of push for the opposition to address the Constitutional Court. And to tell the truth, our opposition sometimes is lazy, because when you have the right, then you can think whether you use it or not use it. And 141 member of parliament, 29 is needed to address the Constitutional Court.
Thank you. Ivo, any comments?
Yes, I do have, although I already spoke quite long about that topic, but I would once again summarize that. I do think the access of opposition and access of every member of parliament is very important for democracy in questions of rights of parliament members. If they are restricted in the parliamentary procedure, And this possibility is guaranteed in our law concerning constitutional review procedure, and we face that one case today in our review panel pending. But what I think would be dangerous to implement nowadays in Estonia is the complaint of the opposition against the law passed in the parliament. I'm very happy when it's functioning well in other countries in our neighborhood, but it could also be misused, and the consequences could be bad for democracy. It might bring the politicians to the idea that to have judicial reforms and to capture the Supreme Court. I can't guarantee that it will be happened, but it is dangerous because such laws are very political, which politicians want to bring to the court.
Thank you, Ivo.
Thank you very much.
Judicial reforms itself are not bad things, but okay, Jānis.
I fully agree with Ineta. So there should be a mechanism how to solve the conflict between different constitutional bodies in the state, because there are places of such conflicts. The second thing is that also the organized part of opposition should have a right to bring the political debate to the court, where the court solves the question of the law and politics, because you cannot split them. Each law, as Ineta told, has an ideology, or we call it a legal aim plan. So you cannot have a pure legal question that will be always with a political background. And yes, in Latvia, 1/5 of the parliament, organized opposition, may submit an application to the Constitutional Court against the law or to the international treaty, like an Istanbul Convention, where to bring the arguments. For example, in Latvia was a case where the members of position, of majority, brings an application as an opposition regarding this Istanbul Convention, using the arguments from the opposition that the Constitutional Court please examine them, that the convention is for a gender ideology, that this will dissolve traditional families, and so on and so on. And the Constitutional Court solved this case and said, our society, you can be live in peace. Istanbul Convention will not infringe your positions and your rights and so on. So this is a mechanism also how the majority can, with the hands of the Constitutional Court, with the highest body and with the highest authority, legal authority in a country, said that, for example, the international treaty, with this is everything is okay. This is how to solve political debate with the legal instruments.
Thank you. Martin, would you like to add something?
Yeah, just, well, it seems very nuanced topic. I'm not sure whether I'm able to give the final position from my side, but maybe what we have also again the context issue that we have at the moment, a situation where the minority recently halted the work of Parliament for several weeks, and now there's the issue about how the procedure of the parliamentary procedure should be set up, and maybe as a compromise, one element could be there that kind of additional rights to turn to the Constitutional Court. At the same time, we have to keep in mind that we have the more general problem in Estonia as regards this parliamentary procedure, because we have problems, for example, in situation where we are in let's say very sensitive situation from let's say security, from these issues where we may end up in some emergency issues where we need very fast work of the parliament, and of course this kind of this instrument can't delay the decisions at the same time. That there should be some balance between these instruments and actually let's say efficiency of the work of the parliament.
Thank you. Now, unfortunately, we have expired our time available, and I would like to thank every and each panelists for contributions, and also audience who carefully listened and asked several questions. Even some questions couldn't be answered. So hopefully it will be put forward some other occasion in future. So thank you for attending this conference, and I hope this was useful and beneficial to learn something and to use even in your own work and doings. So thank you so much. Conference is over.
Üks hetk, kui veel tohib. Me ei leppinud kokku Raidiga et Rait tahtis juba minu eest töö ära teha, aga ma teen enda osa ka ära, nii et aitäh teile kõigil veel tähelepanu eest, aitäh, et te olete lõpuni vastu pidanud, kõige kangemad riigiõiguse sõbrad, nagu ma näen. Ja meil tõepoolest, ma usun, need arutelud õnnestusid, ma usun, et oli sisukas, huvitav päev. Me saame sellega igati rahule jääda. Kindlasti mul on nagu hea meel, et meil õnnestusid ka teemavalikud, et kui ma alguses olin natuke mures, et võib-olla see tänane päev ja kõik, mis meie ümber toimub, et võib-olla siin Eesti poliitilises elus ja parlamendis, et võib-olla see kaaperdab täiesti meie päevakorra ja teemad, aga tundub, et sai neid kahte põhiteemat ka ilma selleta arutada, aga lõpuks ikkagi te ei pääsenud, et ikkagi tulime tagasi jälle selle opositsiooni õiguste juurde ja ma arvan, et kui midagi teha ei ole, et kui elevant on toas, siis temast tuleb ühel hetkel rääkida. Aga see, et osa küsimusi ei esitamata, ei ole ka paha, see näitab seda, et ega ju konverentsid ei leiagi lõplikku tõde, konverentsidel arutatakse, vahetatakse mõtteid ja mul on väga hea meel, et ka selles mõttes meie 2 päeva poolt olid väga niisugused peene sõnaga öeldes representatiivsed, et ma vaatasin, et juristidel oli üksmeelt üsna palju selle küsimuse üle, et ja riigiteadlastele, et kui palju siis saab otsedemokraatia võimalusi kasutada. Mulle tundus, et seal jõuti peaaegu ühisele seisukohale, et olgem ettevaatlikud, pigem mitte, aga mingitel juhtudel natukene võib proovida. Aga nüüd teisel päevapoolel ma vaatasin, kus ikka juristid said päris oma teema kätte, et juba olid niisugused erinevad arvamused ja see kuulub täiesti mitte ainult konverentside juurde, vaid see ju kuulub ka demokraatia juurde, et just üks hea arutelu tuleb maha pidada. Ja et need aruteludest, nagu öeldud, need jätkuvad, aga need tänased arutelud me paneme, nagu öeldakse, purki ka, eks ju. Et nad on salvestatud, me paneme nad ka pärast interneti välja, kui kellelgi on soov järele vaadata, siis see on täiesti võimalik. Me ei teinud enam seda, et me kohe algusest kanname seda üle, sest ma arvan, et siis see saal nii täis poleks kindlasti olnud. Ma tänan kõiki esinejaid, ma tänan ettekandjad, arutlejaid, arutelu juhtidele suur tänu selle konverentsi õnnestumise eest ja eriti suur tänu kuulub meie konverentsi korraldajatele eesotsas mees või õigemini naiskonnale tuleb öelda Gerdiga. Gerdi Raud on Riigiõiguse sihtkapitali tegevjuht, aga teda aitasid ka tublid kolleegid Teaduste Akadeemiast, Silja Kala, kes teeb teile juba ukse lahti, et te saaksite ilusti minna juba suupistete juurde proua Margit Lehis aitas meid, Krista Tamm aitas teha kommunikatsiooni, Kadri Krepstein aitas meil siin inimesi sisse-välja kogu päeva jooksul. Ma tänan meie kolleege Riigiõiguse sihtkapitali nõukojas Priit Pikamäed ja Rait Marusted, kes aitasid kokku panna see programmi ja just nimelt need teemad välja valida. Ja kõige suurem tänu veel lõpetuseks kuulub tõlkidele, kes te kõik kenasti vastu pidasite ja jõudsite kõik selle jutu panna siis kahte keelde. Ja ma usun, et isegi täitsa on võimalik Eesti riigiõigus, mis on rahvuslik nähtus, on ka võimalik rahvusvaheliselt inglise keeles ka arutada. Et võib-olla see on julgustav meile. Loomulikult me ei saa seda pidada ainult inglise keeles need arutelusid teha, aga niimoodi vaheldumisi tundub, et on täitsa võimalik. Suur aitäh teile veel kord selle eest, kes te olete vastu pidanud ja tänutäheks teile on meil sinna välja üks väike laud kaetud, te võite võtta sealt suupisted ja klaasi veini ja need jutud, mis jäid siin nüüd rääkimata, need jutud saate te siis seal lõpuni rääkida ja küsimused, mis teid küsimata, võib-olla õnnestub ka need ära esitada. Ma loodan kohtuda teiega mõnel järgmisel korral ja ma arvan, et riigiõigus väärib seda, et neid konverentsi oleks tõesti rohkem kui ainult pidupäevadel. Aitäh teile ja head õhtut, head nädalavahetust!